It is a very common request that parties who are involved with the Division of Child Protection and Permanency would like to have their communications go through their attorney. The problem with making this request is that a lot of times there are communications that the agency needs to have that make it time sensitive and difficult in order to get the attorneys involved. For instance, the agency has to come out to the parent's home at least once every 30 days. If those visits were to happen as unannounced visits, then of course their attorney would not be there. If they're announced visits, they could technically be scheduled with the attorney, but sometimes there are time restrictions on how quickly they have to turn those around. It makes it harder for the parent to actually have their attorney there. Other concerns are that the agency has certain minimum responsibilities in terms of offering assistance to the family. They have to ensure that the services that they have put in place are working. They have to ensure that the parent is complying with those services. And if the parent is not complying with the services, they have to offer assistance that may address the concern. For instance, transportation assistance, or perhaps changing providers. If they don't communicate with you on a regular basis, they'll have no way of assessing that. Now, that being said, that does not mean that the parent should be having unfettered communications with the caseworker. All communications in the topics about which they are discussing should be discussed with the attorney. The attorney should be advising the parent as to what things they should and should not agree to and what topics they should and should not discuss.